to you or hold it. It's just an extra mic to make sure that. How can I clip it? Like this. Can you do that? Of course. So I can reach there. Perfect. Thank you very much.
Okay, good morning, everybody. First of all, welcome to University of Liverpool. I hope you had a safe trip here. But you face two delays and training chat. My name is Adanan. I'm a lecturer here at the Social Justice, and I'm chairing the committee this morning. Beside me, we have three fantastic PhD candidates. We have Res from the University of Southampton, we have Ben Hudson from the University of Bristol, and we have Amina, Adanan, EJ Freedom Fellow in International Law, who is also a PhD candidate at NUI Galway. So we get proceedings underway. Each speaker will have approximately 20 minutes, and then we have a general question and answers discussion session. To the 20-minute mark, that would be fantastic.
Hopefully. Thank you. So, good to go?
Yes.
Yeah, perfect. Okay, hello. I'm Adanan from University of Southampton. And my area of research is international criminal law, specifically genocide law. So it's not a cheerful morning topic. Sorry about that. Today, I'm going to argue that in genocide law, lack of clear and coherent conceptualization of two foundational words, genos and cide, leads some confusing judicial understandings of the crime. In this regard, I shall defend that there are actually two different, incoherent conceptualization of genocide. Yet current legal approach is stuck in between because while the legal definition of genocide is ambiguous, international courts and tribunals, in the face of this ambiguity, usually are strictly adhering to conceptually confused and problematic preparatory works of the Genocide Convention. As a possible solution, I will offer that revisiting theoretical foundations of the crime might be more plausible in the consideration of genocide cases, compared to an overly formalistic approach. My presentation will start with some theoretical discussions. Afterward, I will demonstrate the impact of these theoretical discussions over the real-life cases by using the example of Srebrenica. But before, in order to explain the issue and its importance, I will quickly go through the legal notion of genocide. The term genocide is coined by Polish jurist Raphael Lemkin, the gentleman in the picture, in 1944. Lemkin combined the Greek word genos, which means family, race, tribe, nation, with Latin suffix cide, which means killing. After Lemkin's extraordinary personal efforts and some lengthy discussions between the states, Article 2 of the Genocide Convention put forward the existing legal definition of genocide. So this is the never-changing, constantly reproduced legal definition of genocide. One of the most interesting things about the crime is the difference between the legal definition and the social perception of the crime. People outside of the legal field usually picture millions of deaths, death camps like Auschwitz, or death marches. But as you can see, genocide is not just about mass killing. The actus reus element of the crime describes 5 genocidal acts, and only one of them, A, is directly about killing. More strikingly, even a single genocidal act is technically sufficient to commit the crime. It is because the legal definition clearly indicates that not the actus reus, but the specific intent element of the crime is the distinctive factor. According to legal definition, one of these five acts can constitute the crime of genocide only if it is committed with the specific intent, which is intent to destroy in whole or in part a national, ethnic, racial, or religious group as such. So the specific intent requirement creates the technical uniqueness of the crime. We have already pointed out that even a single act can constitute the crime if specific intent requirement is there. And moreover, owing to the phrase in whole or in part, intended partial destruction of the group is sufficient for the fulfillment of specific intent element. This is an important point for my further discussion, so we will get to it later. But in a nutshell, intentional atrocities, even if mass killing involved, does not necessarily constitute the crime of genocide. Genocide is a technically unique crime, and this uniqueness comes from the specific intent element, specific intent phrase. Truly, neither the actus reus element, I mean 5 listed acts, or the basic intent that attached to these acts is special to genocide. For example, racially motivated intentional killing of a Bosnian Muslim by a Serbian perpetrator have various characterizations. We can consider such an incident as a domestic major crime if the killing is just an isolated act, or crimes against humanity if the offense is committed as a part of widespread or systematic attack against civilians. Therefore, there are 2 points separate the crime of genocide from its very close kin, crimes against humanity, and all other crimes. The first, in the crimes against humanity, victims of the crime, individuals who are discriminately targeted due to their membership to a group. But in genocide, victim is group itself as a separate and distinct entity. In conjunction with this point, in genocide, the perpetrator has a further and specific goal, special goal, to bring about the destruction of a group as such, rather than merely inflicting harms to individuals. Therefore, in technical definition, genos refers to protected human groups, and site refers not the actual destruction, but the intended destruction of the group. At this juncture, the dilemma of genocide begins. First question comes up to my mind: how can you intend to destroy a group? I mean, does the intended social dissolution of a protected group is sufficient for the fulfillment of specific intent element, or perpetrators necessarily have to exterminate all the members or substantial part of the members? These 2 different perspectives have a deeper root in a usually overlooked question, which is the question of what is a group? In this sense, I argue that, oops, it's early, good. In this sense, I argue that there are 2 different perceptions about human groups. Why it's happening? Cool. Yeah, it's okay, seems okay. In this regard, I argue that there are 2 different perceptions about human groups, about genos, that leads to 2 different understandings as the intended genocidal destruction site. Consequently, we have 2 tales of genocide, 2 different perceptions of genocide. So let me explain this in more depth. The notion of human groups is the rock bottom variable for the different conceptualizations of genocide. In broader social science, existence of human groups have 2 mainstream explanations, namely holist and individualist explanations. And for this reason, actually we have individualist and holist conceptualizations of the crime, of the genocide, because the main victim is group itself. So what's the difference between holist and individualist conceptualization of the crime? Now, holist description of human groups is a realist position. There are many different versions of holism that I cannot cover at that moment fully, but very generally speaking, according to holist approach, groups are real and distinct entities and have some distinct value over the sum of their individual members. In other words, they are complex compositions of different components, just like individual human beings, just like our organs, just like our cells. So they can be destroyed with the destruction of composition as well as destruction of matter itself. Now, if we follow the holist approach, it means the intended social dissolution of the group satisfies specific intent requirement, since social dissolution might lead to destruction of group as an entity. Individual's perspective, on the other hand, and again, there are many versions of it, so I'm only generally speaking, individual's perspective claims that groups are not real entities, but abstraction of multiples of individuals and their actions, interrelations, and dispositions. Therefore, groups have no distinct value over and above the sum of their individual members. If we accept individualist account, we have to accept that groups are all about individuals, and the intended destruction of individuals is an essential element for the specific intent requirement. Now, this individualism versus holism debate has been going on for a long, long time in the social sciences, and none of these approaches is explicitly superior to the other, so there's actually no right answer. However, the text of the legal definition renders both of these conceptualization possible. What creates the problem about the contemporary law is The preparatory works of the Genocide Convention, which is heavily relied on by international courts and tribunals. In preparatory works, drafters described protected groups as holist concepts and examined them as relatively stable organisms, but defended that intended destruction as if groups are individual structures, and concluded that the specific intent merely refers to the physical and biological extermination, destruction of the group. This was mostly because of political reasons, but in any case, jumping from there to there created some peculiar reasonings. Now, one might remind me that the actor stress element of the genocide includes only physical and biological means of destruction. Yes, as it is indicated, while the basic intent is strictly connected with the actor stress element, specific intent has a distinct nature. That is, exclusion of acts of social destruction, such as forbidding practice of religion or language, has little impact over the nature of specific intent. So as an example, let's imagine a situation where all the intellectuals and educated people of a protected group, which is a numerically small part, let's say 2 or 3%, are exterminated by the perpetrator. This satisfies the actus reus element of the crime. At the same time, let's think that the rest of the population deported to a different area where they will be minorities. The question of whether genocide is committed in this situation will be directly connected with the understanding, what we understand from genocide and specific intent. So the closest example, closest real-life example to such a situation was Srebrenica, was 1995 atrocities. In Srebrenica, around 8,000 military-aged Bosnian Muslim men and boys were physically targeted. On the other hand, the rest of the population, approximately 32,000 people, were subject to forced deportation. Now, both ICTY and ICJ rendered genocide convictions regarding the Srebrenica atrocities. But while reaching this conclusion, they tried to stay formalistic, paid extreme attention to preparatory works, and construed the specific intent as intended physical and biological destruction. However, this created some illogical outcomes, because how can we conclude that perpetrators' intention was physical and biological destruction of Bosnian Muslims in Srebrenica if most of the population was subject to forced deportation? On the other hand, the intended destruction is related with the social, if the intended destruction related with the social dissolution, then characterization of genocide might be correct, because these acts clearly aim the social dissolution of Bosnian Muslims in Srebrenica. But if it is so obvious, how come judges rendered genocide convictions while they technically defended that the intended destruction refers only to physical and biological extermination? The answer, by the words of Professor Klaus Kress, is that the ICTY and ICJ used the interpretation of substantiality as a backdoor to introduce social dissolution to the specific intent requirement. As you may call, the specific intent means intent to destroy in whole or in part a protected group as such. But what constitutes a part of a group in genocide law? Now, if you think it plainly, even a single member can constitute a part. Of course, this kind of an interpretation contradicts with the nature of the crime or any teleological or historical interpretation of law, but we cannot tell either 1,000, a million, 50% of the whole group, or something else constitute as a part of a group. And strikingly, it's always about the part, because even Adolf Hitler did not target all the Jewish people on the world, only targeted European Jewish people. This ambiguity has led the emergence of so-called substantiality requirement, which is widely accepted in international law. According to this requirement, the targeted part must have a substantial nature. However, using the adjective substantial has not settled the problem, but led to some different approaches. There are 3 approaches in international law, but I don't have time to go through all of them in detail, so I will really briefly explain them. According to quantitative approach, which maintains that substantiality refers to numerical magnitude of the targeted part compared to whole group. Second is qualitative approach, according to what matters in substantiality is the functional significance of the group for the survival of whole. And according to geographical approach, a part of a group might be limited to a single region or community which is geographically distinct or significant. Now the thing is, qualitative and geographical approaches usually contradict with the individualist understanding that argues that destruction merely refers to physical and biological destruction. Because most of the time, functionally or geographically significant part is a numerically small one that has no real impact over the physical survival of the group physical or biological survival of the group. Therefore, in Srebrenica, the judges adhered to preparatory works on paper, but in fact, they introduced the social dissolution to the specific intent requirement by relying on qualitative and geographical approaches. And this is problematic because this threatens the legitimacy of law and coherency of legal application, because it's completely unclear in what order we are going to consider these approaches, or what legitimizes the application of certain approach to a certain situation. So it's all up to judges using or not using the backdoor of substantiality. For example, if judges use a quantitative approach rather than other two in Srebrenica, the verdict probably would not be genocide, but crimes against humanity. So my conclusion is a simple one. We need a coherent and consistent judicial conceptualization of the crime. It has to be judicial because the legal definitions stay the same for over 65 years, despite all the criticisms, and it is unlikely to see any change soon. However, and perhaps luckily, the text is open to different interpretations due to its ambiguous nature. However, when they faced the problems owing to this ambiguity, international legal bodies usually resort to lengthy and confusing preparatory works. This formalistic manner overshadowed the much-needed attention and examination on the object and purpose of the convention. And it should be noted in here, Article 31 of the Vienna Convention on the Law of Treaties states that the terms of a treaty will be interpreted in their context and in the light of object and purpose of the treaty, and preparatory works, on the other hand, are only supplementary documents in the interpretation process. Yet in the case of genocide, courts and tribunals act as if preparatory works are primary interpretative tools. So according to my view, problem arises from the legal conceptualization problem of the crime, and the preparatory works offer little help or clarity in this regard. Therefore, we need to focus on legal, philosophical, sociological, political theories that shape the law, and then critically reconsider the current interpretation of genos and cite. In this sense, substantiality can play an important role if international courts and tribunals recognize the conflict between current approaches, because simply qualitative and geographical approach supports the holistic conceptualization of the crime, while quantitative approach offers an individualist understanding of genocide. So in conclusion, international courts and tribunals should offer a consistent legal conceptualization, whether it's holist or individualist, in the light of their conceptual examinations according to the object and purpose of the treaty. So I hope it was not too boring. So thanks for listening.
Thank you very much, Umar, for your very interesting presentation. So next we have Ben Hudson, and his paper is entitled Human Rights Protection and Involuntary Migration, Appraising Human Guiding Principles and Internal Displacement.
This might be more difficult than it looks.
It's really hard to try.
Leave on the table. Yeah. I'm trying a new way today. Can you hear? Of not relying on a PowerPoint presentation if I'm teaching, so we'll see how this goes. But hello, everyone. Good morning. It's a pleasure for me to be here. It's my first visit to University of Liverpool, so it's really lovely. I'd like to thank the Conference Organising Committee and everyone here at Liverpool for having me. My name is Ben Hudson. I'm a second-year PhD candidate at the University of Bristol, and my research funded by the ESRC. Today, I'm going to be talking about my PhD topic and one specific aspect of it, the UN Guiding Principles on Internal Displacement. This is an emerging issue that has received much attention in recent years, internal displacement being the involuntary movement of persons from their homes or places of habitual residence to somewhere else within the same internationally recognized state for reasons, a non-exhaustive list of reasons, including conflict and violence, which we traditionally understand as being triggers for people to be fled from their homes, and also situations of generalized violence, violations of human rights, but also importantly, natural or human-made disasters also. As I said, today I'm going to be talking specifically on the primary instrument in regards to the rights and protections of internally displaced persons, those being the UN Guiding Principles. So first I'll do a quick overview of the Guiding Principles. Then I'm going to look specifically at the Guiding Principles as soft law, thinking about the reasoning. Sorry, I just saw everyone's eyes go like that. I was like, what's happening? I was like, I didn't prepare anything. So firstly, guiding principles overview, and secondly, guiding principles specifically at soft law. And then third, I'm going to consider the approach taken, this being the soft law approach in regards to the substantive provisions in the guiding principles, in particular movement-related needs of IDPs, which is what my research is specifically focused on. And I'm going to consider the impact that this has had on the needs and on the provisions within the principles before then concluding. So the guiding principles, a rather niche part of international law, if I can call it international law at all, drafted in 1998, but they are widely recognized as the most authoritative statement at the international level specific to the protection of internally displaced persons. Their development arose out of an increasing concern of what was seen as the global crisis of internal displacement. By 1998, for instance, the numbers of IDPs had increased significantly from 1.2 million in 1982 to 28 million by the mid-1990s, and that is just as a result of conflict and violence. As I'm sure you're all aware, this number continues to escalate today. 2014, in fact, saw the highest single-year increase in the number of conflict and violence-induced IDPs, with the total number of IDPs by the end of 2014 standing at 38 million. If we add this to the estimated total of 19.3 million displaced as a result of disasters in 2014, we now have a total figure that surpasses what we have seen before in regards to internal displacement and more than double the amount of refugees present in the world. So there was a clear need for the guiding principles. The headline purpose being to address the specific needs of internally displaced persons worldwide. What they do is they identify and they provide guidance on the rights and guarantees that are relevant to IDP's protection at all stages of displacement. So that includes protection during displacement, protection during return, resettlement or reintegration, and also importantly, protections against forced displacement in the very first place. In regards to the enjoyment of the provisions contained within the guiding principles, it's quite self-evident that they apply to internally displaced persons, the definition of which is provided in the preamble to the guiding principles. The majority of the principles do concern protection during displacement, and that they should be enjoyed without discrimination. Particular attention is also drawn to particular types of or categories of internally displaced persons, those who may need additional specific needs, for instance, persons with disabilities, elderly persons, children, and also Indigenous people and Indigenous and tribal peoples. But as I mentioned, I sort of want to highlight that the guiding principles, in my view, are really quite important because they don't just apply to displaced persons in themselves, they also technically apply to all of us in that they provide protections to everybody, to all human beings. From prevention of displacement in the very first place. They are also more expensive than that. They in fact include protections for persons engaged in humanitarian assistance also, including respect and protection for their transport and supplies. I think it's important to point that out because I do want to raise the fact that the guiding principles really do provide a much more expansive view of displacement and protections and really the reality of situations of displacement than what we've seen perhaps previously in international law. But perhaps that doesn't quite go far enough, or there still remain gaps, which is what I will explore. So as I said, they provide guidance, and their focus really is providing practical guidance on the protection of IDPs to certain actors. So first of all, there's the representative of the Secretary General on internally displaced persons, who is now known as the Special Rapporteur, in carrying out his or her mandate, always been a his so far, to states that are faced with the phenomenon of internal displacement, but also to all other authorities, groups and persons in their relations with IDPs, including intergovernmental and non-governmental organisations. The guiding principles are also intended to be an instrument for public policy education and consciousness of raising, as well as having a potential to perform a preventative function. However, the principles aren't only intended to guide these actors, they do place obligations on such actors in regards to their relevant activities with internally displaced persons. The primary duty and responsibility, it is expressed clearly throughout the guiding principles, lies with national authorities. They are primarily responsible to provide protection and assistance to IDPs within their own jurisdiction, including humanitarian assistance. However, all other groups who are involved in displacement and are involved in protecting internally displaced persons, irrespective of their legal status, also have specific obligations and should adhere to the minimum standards provided within the guiding principles. However, while these obligations do exist, any obligations in the guiding principles are not binding. The guiding principles are a soft law instrument. Indeed, they provide a normative framework on internal displacement, not an international treaty, and instead intended as a persuasive statement in regards to the actions of those who are involved in protecting people from and during displacement. Strictly speaking, I guess the guiding principles aren't even really soft law as traditionally understood, because their development was, they were prepared and drafted completely independent of states. There was a request by the Commission on Human Rights, as it was then, to create a series of principles. This responsibility for this given to the representative of the Secretary General at the time, Francis Dane, but he worked with a group of independent non-governmental experts in order to prepare drafts and subsequently present these to the Commission in 1998. Now, the decision for the guiding principles to be a soft law document was completely intentional and, in fact, strategic. A number of concerns, which I'm sure you're all aware of, were raised in regards to the desirability and the viability of creating an international treaty on internal displacement. First, there's the obvious, how realistic it is to create an international treaty these days. We're talking at the end of the 20th century, an urgent situation, a phenomenon that required a response, a quick response, and the significant length of time that treaty law takes to develop, and waiting around perhaps for customary law also, was just deemed to be insufficient. Second, whether there'd even be consensus on what would be contained within an international treaty on internal displacement, and what compromises may have to be reached in order to ensure that consensus could be reached. And then even if we have consensus, whether states would actually ratify the instrument, and whether, more importantly, those states that are affected by internal displacement would ratify the instrument. I'd also like to highlight that, I mean, a lot of states are affected by internal displacement. It's not just the typical, or those that we think of, the Middle East and so on. You know, the UK would technically has responsibilities to protect individuals who would be deemed to be internally displaced as a result of flooding. But there is still an issue that those states that are most susceptible or experience internal displacement may be the least likely to sign any such document anyway. And fourth, there's also uncertainty which still exists in regards to, as I was suggesting earlier, the expansive nature of the guiding principles. The expansive nature means that really internal displacement is to be seen as a human rights issue, but it does clearly expand beyond that to human rights, to humanitarian, and by analogy, refugee situations, and also many, many development concerns. So trying to bring all of that together without diluting the provisions that already exist in international law was a key concern at the time. But despite all of these sort of logistical and practical concerns, the main reason for why the guiding principles were decided to be a soft law document was because research had shown that it was believed there was no need to create new law. There was no need for new binding law to be created for internally displaced persons. The research that had been conducted, which had been requested in advance of the guiding principles by the representative of the Secretary General, claimed or stated that there were sufficient provisions already set forth in international law. Therefore, it was possible to create a comprehensive set of principles for the protection of internally displaced persons by simply reiterating such rights and clearly applying them to internally displaced situations, inferring such rights from other, or clearly outlining them more, I guess, in regards to the displacement context, so as to strengthen their protection, or by analogizing IDP rights from existing provisions. As a result, we have quite an expansive document full of many, many principles, which do not, and strictly, explicitly do not provide new law, simply restate existing provisions. Now, this approach, has it been successful in regards to the substance of the guiding principles? I'm going to focus on movement-related needs. I mean, movement-related needs are key to the internal displacement context, indeed inherent through the actual process of displacement. An individual cannot enjoy their freedom of the right to liberty of movement throughout the entire territory of their country, as established in the International Covenant on Civil and Political Rights, Article 12.1. This is violated. The guiding principles do obviously therefore address movement-related needs in principles 14, 15, and 28. Now, just to quickly rattle through, but I think it's important to highlight what it does cover before then thinking about what it does not. Principle 14.1 states that every IDP has the right to liberty of movement during their displacement. Now, that right is almost identical to that found in ICCPR 12.1, a simple reiteration if you think back to the model from before. Principle 15a states that IDPs have the right to seek safety in other parts of their country. Again, extending, it is in relation to movement within the same state, and that to do so would not jeopardize any return for those individuals. But it also says that an IDP can seek asylum abroad, they can travel abroad and seek asylum, and that any internal displacement prior to that movement does not itself jeopardize the right to seek asylum. Here, we're not creating anything new. We're clearly just reiterating key rights in human rights law to the displacement situation. In returns to return, Principle 15D provides that for an IDP has the right to be protected from forcible return or resettlement to any place of risk within the same country. Now, this one is a little bit more of a complex right in regards to its legal foundations. We all know about, in refugee law, the principle of non-refoulement. Well, that applies strictly in regards to refugee situations, but it was decided that it was possible, and there are many, many similarities, particularly in regards to political conflict and violence triggers for displacement, that internal displacement situations, the provisions of refugee law could be analogized from there, therefore meaning that IDPs have the protection from being forced to anywhere of risk within that state, which they remain. So far, so good. But now we come to a key point, which is the key point I find most interesting, is that of return. International law, particularly international human rights law, clearly and fundamentally states a right to return to one's own country. But it's clear, the right to one's own country does not apply in situations of internal displacement. It would apply in regards to refugees who are outside of their own country, but IDPs remain within. Therefore, to say that IDPs have a right to return to their own country does not particularly add anything, unless they were to seek asylum and then wish to return. But this wasn't followed up on particularly in regards to the development of the guiding principles. What was focused on more was thinking back to Article 12.1 again in regards to freedom of movement. Now, the research conducted prior to the guiding principles, there was a document called the Comprehensive Analysis. This stated that IDPs do not have, strictly speaking, an explicit right to return to their homes after the displacement has ceased, and the reasons for displacement have ceased, but that this right could be deduced from a right to freedom of movement within one's own country. The issue being that this wasn't clear enough, and that what we needed to see in the guiding principles was an explicit, comprehensive right, a guarantee that IDPs have the right to return to their homes, and to prevent them to not do so would violate their fundamental human rights. But when we look at the guiding principles, there's a strange twist, there's a strange change in the language. And when we're talking about return, when we're talking about solutions to displacement, we do not see the rights language. What we see instead is, and it's very good to see, the responsibility of states once again to provide conditions and to provide the means by which IDPs can return, but it falls short of providing an explicit right. It does not say It says that IDPs have a right to move to another part of the country. It says that IDPs have a right to freedom of movement while they are displaced. But what it does not state is that IDPs have a right to return to their homes. So why may this be? Well, it might be because a right to return does already exist in international law that is applicable to IDPs. But as I've already said, the right to return as currently conceptualized in international law is firmly focused on international movement, and therefore this does not apply to IDP situations and has not been extended any further from that. But to say that there is no right to return for IDPs in international law would perhaps be stretching it too far. We do see a couple of examples of where IDPs return can be secured, and this is through the ICRC Rule 132, so Customary International Humanitarian Law, which states that persons displaced as a result of non-international armed conflicts have a right to voluntary return as soon as safe to do so and as soon as the reasons for displacement cease to exist. Yet this is clearly strictly limited to situations of non-international armed conflict. One of the key points that the guiding principles tries to resolve in that internal displacement is not simply as a result of conflict, international or internal, but for many other reasons. Therefore, this provision in international law, customary as it is, does not apply to a large majority of internally displaced persons. Similarly, ILO Convention number 169, which concerns indigenous and tribal people's rights, interestingly states that these peoples have a right to return to their traditional lands following displacement, or specifically following relocation. But this, self-evidently, only applies to indigenous and tribal peoples, again, who may be IDPs, but again, this is not a comprehensive right. It does not, as I said before, cover all triggers of internal displacement and therefore fall short of providing a provision for all internally displaced persons. So there is a clear need, and there was a clear recommendation stated prior to the guiding principles being developed that this provision, this right to return, should be clearly guaranteed for internally displaced persons, but it's not. Now, why is this the case? Well, I wish I could give you a comprehensive and clear answer to why, but I guess this is what interesting to research. It's not easy to be found. This has led me to speculate, perhaps this has been missed. Perhaps this is an error. During the research, during the drafting, perhaps simply this right got lost, or it was reinterpreted in a different way, and unforeseen that this would reduce the rights of IDPs. Or perhaps, and I think this is something that is particularly interesting, which I'm going to continue looking at, perhaps it is as a result of the soft law status itself. Now, this is a complicated issue because the recommendations did state that this should be provided. And even if a provision existed in international law, I see no reason for why it's not restated in the guiding principles themselves, given that they do stay within existing law. But what I fear is that while it is recognized that IDPs do have a right to movement, the international community is yet to recognize that an international legal framework can insist and can provide protections for internally displaced persons, giving them the rights themselves to challenge their displacement. And I fear that the approach taken, the approach that this is soft law that does not go beyond what already exists, but instead relies on the already fundamental foundations of international law. By relying on that, what we have now is a situation where there is no right to return, and internally displaced persons have no way in international, let alone international law, not even in guiding principles in international frameworks, to challenge their displacement themselves. Now, I hope to discuss this more with those who drafted the the good principles later this year to uncover why this is the case. But what I do believe is that an opportunity has been missed. The guiding principles are not legally binding. Some may see that as a negative, a sacrifice. But what we could have had instead would be a vast, expansive, far-reaching, norm-creating document that would have stated these rights that maybe they do not really exist in international law, but we can develop them in that way. But by strictly remaining within what exists, I believe the guiding principles have continued to allow gaps to be there, to exist within international frameworks, and I believe this contributes to the situation we have at present in regards to internal displacement. Thank you.
Okay, our third and final paper this morning is presented by Amina Adanan from AUI Galway. The title of the paper is Universal Jurisdiction over War Crimes Committed in Non-International Armed Conflicts.
Will it go up on the screen as well, just so I can see?
Let's see, the screen has gone to sleep.
Oh, right. Yeah, sure. Good. I'll work off the screen. Yeah, that's grand. Thanks. Thanks very much, Anne-Marie. And thank you very much to the organisers of the conference for having me here today. It's a pleasure to speak here at the university. So today I'm going to present to you, it's a section of my research from my PhD. My PhD topic is universal jurisdiction in international law. And so today I'm just going to focus on the right of states to exercise universal jurisdiction over war crimes committed in non-international armed conflict. When I talk about non-international armed conflict, I'll use that phrase interchangeably with internal armed conflict. And what I'm talking about are armed conflicts not of an international character, which take place within the boundaries of one state, which can involve armed groups or non-state actors involved in an armed conflict against maybe state forces or armed groups fighting amongst themselves as well. So when we talk about war crimes, we're talking about serious violations of customary or treaty rules belonging to international humanitarian law. International humanitarian law obviously being the laws and rules that govern war. So that definition that I'm working with is from Casese and others. So war crimes, they are criminalized both in national law and in international law. In national law, some states have chosen to criminalize war crimes that are committed in both international and non-international armed conflict, whereas other states have chosen just to criminalize war crimes committed in international armed conflict. Traditionally, there was a clear divide in the sets of rules that applied to the rules of international humanitarian law in respect of international armed conflict, and there was a different set of rules for non-international armed conflict. However, since I suppose since the 1970s onwards, there's been a clear kind of convergence of the two sets of rules, and this was expressly affirmed by the International Criminal Tribunal for the former Yugoslavia in the famous Tadic jurisprudence in the 1990s. And it's important to remember that when we're talking about war crimes, the act itself, the acts can include murder, torture, inhuman treatment, and also offences against property as well. And it's important that the crime is committed in the context of the war, of the armed conflict. Otherwise, if it might have to do with a domestic dispute, national criminal law will apply rather than international criminal law. So the primary responsibility for the implementation of international humanitarian law it lies with states themselves, and obviously the place in a state where when a violation occurs, it's going to be up to the national court to respond, whether it be the territorial state or the state of nationality of some of the nationals involved in the violation itself. It's a bit like Ben was saying in respect of the guiding principles for IDPs. Again, it's the state's responsibility rather than, I suppose, rather than anything else. This kind of, I suppose, principle was expressly reaffirmed in Article 17 of the Rome Statute of the International Criminal Court, and in the preamble of the Rome Statute as well, which talks about that the court is complementary to national courts, and the primary responsibility for redress for violations for international crimes will lie with national courts themselves. When you look at I suppose war crimes committed within a state's territory, within state boundaries, the territorial state will often be the state of nationality of the perpetrator and the victims, because it's happening within the one state. Often what happens is the territorial state may not actually be in a position to deal with the prosecution itself. There may be political reasons for this. The prosecution of international crimes is a highly politicized affair for states anyway. But if you couple that with a post-conflict state, and they may not have the legal infrastructure in place to actually deal with the punishment itself. Another issue that arises in this area is that the ICC itself mightn't actually be in a position to punish the war crime that's been committed in an internal armed conflict. Obviously, they have a limited amount of resources that they have to work with, coupled with the length of time it takes for cases to come to fruition. So for this reason, there is a void that exists whereby the territorial state or the International Criminal Court may not actually be able to punish the offence. So for this reason, universal jurisdiction is really, really important in respect of war crimes committed in internal armed conflict. So this is, as I'm sure you're all aware, this is the capacity or the right of a state to punish an international crime in its own national courts when the crime has been committed abroad and involves nationals who are not the same nationality as the forum state or the state that's carrying out the prosecution. So it's provided for in conventional international humanitarian law in respect of grave breaches of the Geneva Conventions, which relate to international armed conflict. So the grave breaches regime asserts that state parties to the Geneva Conventions, that they have to legislate, I suppose they have to criminalise the commission of grave breaches wherever they occur. Not only that, but when they are aware that an alleged perpetrator or someone who is alleged to have ordered other people to commit grave breaches, if that person is in the territory of a state, that state is obligated to search for that individual, to take them into custody, and either to punish them themselves in their own national courts or transfer them, extradite them to another country who has evidence to show that the person has committed such crimes. So it's a really, really stringent regime that is in place there. However, if we look to non-international armed conflict and the governing, international law instrument for non-international armed conflict is Additional Protocol 2 to the Geneva Conventions, and also Common Article 3 of the 4 Geneva Conventions themselves. So basically, there is this legal void that exists. Then how do you deal with acts that are war crimes that are committed in a non-international armed conflict? And so for this reason, the question arises whether or not customary international law confers on states the right universal jurisdiction over war crimes committed in non-international armed conflict. So I believe, for a number of reasons, that the question can be answered in the affirmative. So today I just wanted to put forth my ideas on why I believe the customary right does exist. So first of all, universal jurisdiction itself is a rationale-based crime. So this means that I suppose the jurisdiction is activated, if you like, when a heinous act is committed. I suppose anywhere. It's the gravity of the act itself that activates this consequence. As was famously stated in the Eichmann jurisprudence from the 1960s, where the Israeli Supreme Court stated that it's the particular universal character of these crimes, international crimes, that vests in each state the power to try and punish anyone who assists in their commission. And this rationale has been followed up in subsequent case law in mostly European states, but also in some US jurisprudence and Australian jurisprudence as well. So if we look to the commentaries on the Geneva Conventions themselves as to why the grave breaches regime was included in the treaty, they state that the reason was that the crimes must not go unpunished, that they're so heinous. And so again, you've got the rationale for universal jurisdiction there is that the crimes are so heinous themselves. So thus, I would argue, universal jurisdiction, if it's, I suppose it stems from the heinous nature of the act itself. It is not concerned with the characterization of the armed conflict, whether it's international or non-international, because it's the act itself. So you can't say that that torture committed in an internal armed conflict is no less heinous than torture committed in an international armed conflict. It is heinous, full stop. Second of all, it has been declared by the International Criminal Tribunal for Yugoslavia that war crimes are deemed a jus cogens offence. So they're in the category of offences that receive this privileged status of protection. They are, I suppose, they're universally abhorred by states the world over. Other examples of crimes in this category are the prohibition on slavery, torture, prohibition on genocide as well. And evidence of the universal abhorrence of such acts can be found in the Rome Statute itself. The fact that war crimes committed in international and internal armed conflict are criminalized in the statute. Not only that, but at the Rome Diplomatic Conference that led to the creation of the Rome Statute, it was states that participated in that, even states that subsequently have not signed the Rome Statute, still supported the criminalization of war crimes committed in non-international armed conflict. And another point of note is the fact that when the negotiations were going on, it was the belief of the states involved that the list of crimes included or the list of war crimes included in the statute, both committed during non-international armed conflict and international armed conflict, that they should reflect customary international law as opposed to creating new specific crimes. So that would be further evidence that the war crimes specified that are prohibited in non-international armed conflict in the Rome Statute itself are evidence of the universal abhorrence by the states who created the treaty. So what's the consequence of a jus cogens norm when it is breached? So as was stated in the famous Ferendizia case at the ICTY, now this statement was made in respect of the jus cogens status afforded to the prohibition against torture, that every state is entitled to investigate, prosecute, and punish or extradite the alleged perpetrator of the jus cogens act. that has been committed. So basically there, what the court was talking about there in that instance was the obligation to try or extradite, which is found in the grave breaches regime of the Geneva Conventions. It is also found in the UN Convention Against Torture in respect of torture. Basically, it means that whenever an individual who's suspected of having committed a particular offence is on a state territory, that state, when the person is in their custody, that state has to either extradite the individual abroad to another state who's going to punish the offender, or they have to carry out the trial themselves. But how is a state going to exert its jurisdiction over an alien who is in their territory, who's in their custody, if that person has committed the offence abroad against victims who are not nationals of the forum state? What happens in that instance? Well, the state in question is going to have to incorporate universal jurisdiction into their national law in order for them to be able to punish the offence if they're going to fulfill this obligation. So that's one way, I suppose that is one way that shows that universal jurisdiction is a part of this Hughes-Coggins framework, and is one of the responses to a violation when it occurs. So hand in hand with Hughes-Coggins comes erga omnes obligations in international law as well. Now these are slightly different, but even though it is an obligation that applies to some of the offences that are deemed Hughes-Coggins offences, such as the prohibition on genocide, prohibition on war crimes, prohibition of racial discrimination. So what this means is that states, they have these erga omnes obligations that they owe to other members of the international community, other states. So basically, whenever an offence in that category of offences occurs, that any state has or may seek reparations on behalf of the victims. So that can include both civil and criminal reparations. But for the purposes of this research, I'm just focused on criminal reparations. So even though the state may not themselves or their nationals be part of the offence, they still have this obligation to seek redress for the offence that has happened. But obviously, a state is going to seek reparations when it's in their national interest to do so, because otherwise states, I suppose, they wouldn't be motivated to prosecute the offender otherwise. So again, you can use the same evidence from the Rome Statute, from the Rome Conference in support of that. The fact that war crimes committed in non-international armed conflict should be and are included in this erga omnes list of crimes as well. Further evidence in support of a customary right to exercise universal jurisdiction can be found in the opinio juris and state practice as well. States do legislate for universal jurisdiction over war crimes committed in non-international armed conflict, and they also punish individuals who are accused of such crimes as well. I'm just going to fly through this now because I'm running out of time. I would say that it's important for in the case law that has occurred in such instances that the accused is present on the territory of the forum state, and also it's often linked to asylum law in some way. The perpetrator, as with any internal armed conflict, when persons are fleeing to another state, you can have perpetrators, war criminals in that cohort of individuals who are moving as well, and they obviously they may seek asylum as well as refugees who are fleeing as well. However, states I suppose the UN Convention on Refugee, or the Refugee Convention, the provisions of it don't apply to persons who are alleged to have committed or persons who have committed violations such as international crimes or principles in violation of the UN principles. States are, the Lotus Principle also states that states are allowed to exercise extraterritorial jurisdiction so long as they don't interfere with other principles of international law. So in the famous arrest warrant case from the ICJ, it was held that universal jurisdiction, or a state can't issue an arrest warrant against an incumbent head of state under universal jurisdiction. However, the door has been left open for when the individual has left the office and is no longer head of state in respect of offences committed in a private capacity. It's important to remember this is a right of states and not an obligation, and also that the territorial state and state of nationality will have priority to punish the offence. So just quickly to conclude, ultimately, this is one area of international humanitarian law that needs to be strengthened in the whole realm of IHL, which needs to be strengthened overall in many parts. Ideally, it would be wonderful if there was an international treaty that would allow for this right to be codified. Now, the right does exist. Universal jurisdiction does apply in non-international armed conflict in respect of offences to do with cultural property, and that's under the second protocol to the Hague Convention on the Protection of Cultural Property during armed conflict. But aside from that, in respect of offences against persons or persons who are ordered to combat and civilians, there is obviously a need for a codification of this right. However, as Ben was saying about in respect of IDPs, it'd be great if there was an international treaty, but obviously it's easier said than done. One way that perhaps this could be strengthened is to link it with asylum law. Again, because states are hardly going to act unless an individual the accused person is on their territory. And no state wants to be a safe haven for war criminals. So if you could link it to asylum law and have it incorporated in that process, it would strengthen the principle. And Canada, actually, they have a fantastic policy as part of their asylum law, where if war criminals do enter their jurisdiction and seek asylum, that they will a prosecution, if the person is suspected of committing war crimes in non-international armed conflict or international armed conflict, that they can be punished in Canada, and they actively use that law and that policy that they have in place. There are other issues that I haven't dealt with that will also pose barriers for the application of universal jurisdiction, even when the law is in place. It's not very black and white, because there could be national and constitutional issues within a state that will impede access to justice for victims of international crimes, of war crimes committed in non-international armed conflict. So I'm just going to finish up there. And this research was funded by the National University of Ireland. So thanks very much. I'd appreciate your comments and questions.
So we have around 50 minutes for general discussion, questions, answers. Okay, so we'll throw it open to the floor. Does anybody have any questions or comments? Okay.
This is for Onora. Do you think that genocide is, I guess, is there less of a need to charge genocide now that crimes against humanity exist? Like, because they often overlap in terms of the conduct, and as you mentioned and discussed quite well, genocide requires a specific intent showing of the intent to destroy the group. Is there a point in charging genocide at this point? Isn't it easier for a prosecution to just charge the same conduct as crimes against humanity and leave the genocide question alone?
It has been claimed by Larry May, an American professor, and who follows the individualistic account. Actually, I took the idea from him because he alleged that he's a nominalist and is strictly follow the individuals account, and he claims that there's no point to keeping the genocide because genocide is actually crimes against humanity, as you said. But we need to think, what is the victim? I mean, if the victims are individuals, as I stated in individualist account, you're right. There is no point because crimes against humanity already protects everything. But if we are talking about the group and if we are giving an extra value to group, then there is no law which protects the group as such. But it's all about what we understand from the group, as I said. And thanks for asking this question because this is to the point. I mean, this is what it's all about. So it's all about what we prefer. And the problem about the contemporary law, they're so ambiguous. I mean, they can't decide whether because they want to keep the genocide because there's a magic in this word. When you say it's a genocide, everybody focus on that, and no matter what's the situation. So it's an interesting situation, but you're totally right, and it has been claimed by many scholars actually, and most recently is Larry May in 2010. So it's a valid point. So it's all about what we understand from the victim.
Any other questions or comments? Ben.
Thank you very much for speaking and for doing a very interesting presentation. Just got a question for Amina. I really enjoyed your paper. I was just struck by the references to how fantastic it would be that there's a treaty and how unfortunate it would be that there isn't a treaty to sort of underpin this the universal jurisdiction right. I was wondering whether you sort of deal with some of the counter arguments to that maybe in like a different part of your thesis. And where does the assumption come from that universal jurisdiction is just inherently a good thing? But also, for example, the extent to which it may come up against principles of state sovereignty, for example, how do we square those two principles? But on that note, it's also just give you an opportunity to talk about one of the other factors that I noticed on the final slide, and how maybe the possibility of underpinning this right in the treaty may just be dominated by Western states, and whether that is a problem.
Thanks very much. That's a really good question. Yeah, on my final slide, I wanted to mention about obviously it is dominated by Western states, the exercise of universal jurisdiction. But that's not to say that other countries outside of Europe and the West don't use universal jurisdiction. They do have, some states do have legislation in place to deal with such offences under universal jurisdiction. I can think of recently there was a case in South Africa under their legislation to do with the International Criminal Court, where it was held that the police there had an obligation to investigate. It was torture. I can't remember if it was crimes against humanity as well, that had been committed in Zimbabwe, and it didn't involve any South African nationals. So, and obviously then you have the Hussein Habre case that's going on in West Africa at the moment. So so it is like African states are, I suppose, showing an interest in it, which is wonderful. But it is obviously the exercise of universal jurisdiction is dominated by Western states, and then it's going to reflect the Western states' interests as well. And I suppose this is part of a wider problem in international criminal law, where it's Eurocentric, and it protects certain interests. And when other countries try and or even even within Western states, when Western leaders, when efforts are made to punish Western leaders for possible international crimes that they have committed, the cases don't come to fruition. And so, I suppose there is definitely that side of universal jurisdiction, which I am addressing in my doctoral research. I think there was something else I was going to say. Oh yeah, that when universal jurisdiction is exercised, like, it is important that there are certain criteria placed on it. I don't think that it's, it should be just used unchecked. Say, for example, I don't believe that, well, my research so far on because I look at kind of like the rationale for universal jurisdiction applying to the crimes it applies to. And in the research that I've done a lot of historical research on this, and it's shown that there isn't much state practice for universal jurisdiction in absentia, where the So where the accused person is not in the forum state itself. So I don't know how you could try and exercise universal jurisdiction in absentia if there's little state practice in that area. And also you have to balance that with the rights of the accused person as well. So that's something else that has come out of my research anyway. But thanks very much. Michelle?
Thank you both very much, Sarah and Mr. Draper. I think I'm a bit late. So I have a question for Ben and for Amina. And in usual, I always ask granty questions that don't necessarily make sense. I'm thinking aloud, so please forgive me if it doesn't make that much sense. But my question for you is, I don't know much about IDs, but it struck me from the start that sometimes I dabble in constitutional law and national law and wonder about the relationship between international and national law. And it does strike me that IDPs is one which seems like a more fitting area for the national state to deal with, more so than international law. So I just want to ask you, why do you think this is an international law issue as such? What are the issues with it that make it an international law issue? Bearing in mind all of those different trigger factors for IDPs. My question for Amina is even more rambly than that. When I was listening to you, I really liked your paper, and when you mentioned Eichmann as a basis, I started to get very excited because we always start with Eichmann, and we always talk about Eichmann as set law, but Eichmann is rooted in problematic practice, which I don't have a problem with problematic practice, but it is. And as you build an argument and you rest it on something like Eichmann, it raises questions around whether you accept the politics that underpins that prosecution. And that's where I start to wonder to what extent you really engage with politics around universal jurisdiction. So it's one of the barriers you mentioned in your conclusion, but for me it's everything. It's all politics to an extent. So I wanted to speak a little bit about that, and connected to that, it seems to me that underpinning universal jurisdiction is a very big unanswerable philosophical question about why we prosecute. And your argument is built quite strongly on the idea that these practices are so heinous that we need to prosecute them. I don't really care so much about heinousness of practices. I prefer punishing people when they're going to do something again. And in many cases, or to get them off the streets if they're a problem. In many cases, it's unlikely that a genocidaire in Canada is going to, they may still be involved in perpetrating or the politics of the country they're from or whatever. But so do you deal with the philosophy of the punishment? I suppose big question.
Okay, well, thank you very much for that question. Actually, I wrote down the same thing. I write things down when I hear myself at the end, and this is something that I'm interested in thinking more and more about, actually, because obviously the reason why internal displacement hasn't really been dealt with at the international level is because it's always been perceived as a domestic issue within the sovereign responsibility of a state. I think the decision made, as I understand it, to move this to the international level really was that the domestic level was not dealing suitably with protecting internally displaced persons, especially in those situations where the state is responsible, complicit in the displacement itself. The interesting question for me, I think, is going forward. And as I understand it, so far, I mean, the present Special Rapporteur on Internally Displaced Persons has made a statement about how his work legally has gone as far as it needs to. And he strongly thinks the soft law approach was a good one because he saw the point of it was to create an agreement across throughout the world, which they have been widely agreed and accepted, that he can use the guiding principles as a tool to then develop domestic law to protect IDPs. I think that I can think of some examples where that's worked quite well and some examples where perhaps it hasn't. Some states, such as India, for example, they recognize that the guiding principles exist, but they do not they don't see them maybe as minimum standards that they're going to adhere to. Most of my experience is from Georgia, because I used to live there and work with internally displaced persons. And Georgia was in a state of no protection whatsoever for internally displaced persons, actively, if I can say this, actively using internal displacement to support their territorial claims and their international conflicts. What the guiding principles did was really just sort of advise and give a focus from the international level to assist the changing Georgian government, as it's changed very rapidly over time, to assist them in what they should be aiming to do. So I think in that way, the international level, it's been suitable. But still, it's the case that in some ways, the Georgian legislation now is almost, if you think about the definition of internally displaced person, which is quite disputed, is almost more expansive in that those who live close to disputed territories could still be considered to be internally displaced domestically if they're affected by the same situation as displaced persons without actually having been displaced. But Georgia will refuses to recognise that people displaced as a result of natural disasters or man-made disasters are considered to be internally displaced. So I think that there's still a mismatch even in those states that do take seriously the guiding principles. Now, whether that means that we need to shore up the international system and make it even stronger, I mean, we could, but whether that would do anything, or whether it would convince any states to change practice, I don't know, or whether we should now be focusing back on a domestic level and working slowly to develop domestic law, I think is a really good question. But I do think that there are still key displacement situations that do require the international level, because many of the violations of human rights that are taking place, the rights that IDPs would have if they left their state do not exist domestically. And in that way, they need to be supported, I think, at the international level.
Any other questions?
I'll just answer.
Oh,
Michelle.
sorry,
Yeah.
my apologies.
No worries. Thanks for your questions, Michelle. Just on your point about ICWN not being a good basis to rest, well, a questionable basis, which it certainly is. There's no doubt about it. It was a highly politicized case, and it's questionable if nowadays a similar, I don't know if nowadays if that sort of circumstances would be allowed to happen, and whether other states would support it or not. But it is, in international criminal law, as you're aware, like it is a fundamental case that we all study, and that is followed in state practice, both on a national and an international level, which obviously then strengthens the ideas put forward in it, and then creates precedent. But it is obviously, it's a special. I think it was Fawcett in writing on the case around the time, he described it as, it was an extraordinary case for extraordinary circumstances. But I suppose it is, scholars still write about it nowadays, and it does have a lasting impact on international criminal law. But that's not to say we shouldn't, I suppose, question it at all. And just your point on, or your question on the philosophical nature of punishment. I know for my own research, I haven't really dealt with philosophy. That's something I'm not entirely comfortable with. I'm more of a traditional lawyer. However, it's something that I may have to consider at some point. And yeah, probably should. I don't know. I don't know. But why do you're asking about, like, why do we punish the crimes? Or why do we prosecute them? I suppose, like, deterrence is a big reason of why, even in national criminal law, what's the point of prosecuting persons? And as you rightly said, that one genocidaire in a Canadian jail, for example, he or she, they're not going to recommit, but that's not to say that it won't deter others from committing if they see that the crime will not be committed with impunity, because unfortunately the vast majority of international crimes committed nowadays are, they're not punished, and they should be. And I suppose that's part of strengthening IHL and other areas of international law as well. I suppose part of the rationale that IHL works on, obviously, is reciprocity. And when it comes to punishment of violations of IHL, particularly in internal armed conflict, if it's states who are signing up to the international treaty, but the treaty then applies to non-state actors, and they don't have, are they able to, obviously that's a whole set of raises a whole another set of issues there. But treaties will still apply to non-state actors, and maybe that's part of the grand problem with why the right to exercise universal jurisdiction in respect of internal armed conflict, why it's not legislated for, is because states do see it as a matter for what happened, you know, for their own business, that what happens in their country is their own business. And I believe that is one of the fundamental reasons why it's not an international treaty yet. Thanks very much.
Okay. I saw a couple of people make comments, but we have actually gone over time, unfortunately. But we'd all be meeting up together on break anyway to have a chat about all these things. Like, again, to thank our wonderful 3 speakers, 3 fantastic papers, well done. And thanks very much as well to the audience for your very interesting questions and comments. Thank you very much. So now I think there is a break, tea, coffee, refreshments, which is available downstairs in the foyer. Okay, thank you very much. Thank you. Just in relation to people, do you remember the debacle in relation to Omar al-Bashir during the summer?
Oh yeah, in